ad hoc and ICC, LCA, Uncitral, SEC, Swiss Chambers, and Moscow cases. He is a co-editor of the book UN Convention on Contracts for the International Sale of Goods, a commentary, along with Professor Stefan Krell and Maria del Pilar Perales Casillas, work that allow us to have the honor of receiving the professor at Camp Santiago in 2011. Professor Miselis was educated in Greece, France, Germany, and Japan.
Thank you, Claudio.
Very much, Professor Miselis, for having accepted our invitation and be here with us today.
Yeah, Lasaka ASCO arbitrator. Sabina Sacco is an independent arbiter based in Geneva, Switzerland, a Chilean, Italian, and Salvadorian national. She currently acts as arbitrator in commercial and investment arbitration, particularly in Latin America and the Spanish-speaking world. With over 15 years of experience in international arbitration, she has acted as president, co-arbitrator, and sole arbitrator in arbitration proceedings under various roles, including ICC, the LCA, and CSD. Her experience spans a variety of industries, including oil and gas, renewable energy, mining, construction, utilities, food, retail, real estate, and international sales. Prior to launching her independent arbitrator practice in 2021, Sabina practiced for several years at leading law firm in Geneva, the United States, and Chile, where she specialized in international dispute resolution and corporate matters. During that time, she was involved in over 30 international arbitration proceedings under various roles as arbitrator, counsel, secretary, or assistant to the arbitral tribunal. Sabina is an active member of arbitral institutions and associations. She is currently a member of the IBA task force for the revision of the IBA rules on the taking of evidence and of the ICC Commission task force on maximum the provide value of witness evidence. She's also a member of the advisory committee of the Madrid Arbitration Court and the Commission of the Scrutiny of Awards of the Madrid International Arbitration Center, and serves on the editorial board of the ICC Dispute Resolution Bulletin. From 2012 to 2015, Sabina was a member of ICC International Court Arbitration representing Chile. And also Sabina holds a law degree from the Pontifical Catholic University of Chile and an LLM from Harvard Law School. She's admitted to the Chile and New York bars. She speaks Spanish, English, Italian, and French. So we have a great opportunity to have you today, Sabina. We are so happy to this opportunity. Thank you for being here today.
Thank you for the invitation.
Thank you, Sabina. And finally, but not least, we have Mr. Neil Blackaby. Nigel is a partner at Freshfield Brookhouse Deringer Law Firm, one of the largest multinational law firms in the world. He specialized in international investment arbitration, international commercial arbitration, and investment disputes. Nigel has acted as counsel and arbitrator in over 100 ad hoc and institutional arbitrations. He is also an adjunct professor of law at the American University of Washington, co-member of the Singapore International Arbitration Center, former president of the IBA Subcommittee on Investment Arbitration, and member of the list of arbitrators of the AIA, Santiago Chamber of Commerce, Lima Chamber of Commerce, and FISP in Brazil. She's co-author of the book Redfern and Hunter on International Arbitration, along Constantine Partacit, Alan Redfern, and Martin Hunter, which was recently published in Spanish for second edition, I think, by Baxter Publishing. Finally, Nigel graduated from the Universidad d'Aix-Marseille in France and from the University of Exeter in the UK. Thank you, Nigel, for joining us today.
Thank you.
So now, that being said, again, congrats to the teams, and we give you the floor to the president of this panel to start the hearing today. Thank you.
Thank you very much, Laura. Thank you very much, Carlos, for all the support, and congratulations to the team to get into that stage. As would normally happen in every arbitration, at the start of the hearing, and actually typically a couple of weeks before, we are engaged in a discussion to ascertain whether the parties have reached any agreement in the way they would like to organize the hearing today. And over to you. Have you discussed with each other about how you would like to organize the hearing today?
Yes, we have agreed. Our respondent, concerning the order of argument, respondent will begin on the procedure, and the claimant will answer, and then followed by rebuttal and rebuttal. And on the merits, the claimant will begin, and the respondent will answer, followed by rebuttal and rebuttal.
And do you have an internal system of checking time? Obviously,
yes,
we will take account of any questions that might come from the tribunal, but you do have. Okay, very good.
Yeah.
Is there anything else you would like to raise with the tribunal at this stage before we formally start?
Just to clarify that not only that is the order that was given by opposing counsel, but also that in that order, both parties will have 14 minutes to address the procedural issues, with 1 minute each for rebuttal and sub-rebuttal. And on the merits, both parties will also have 14 minutes each, plus 1 minute each for rebuttal and sub-rebuttal.
Thank you. And are we right that then Ms. Romina Rossi will go first?
Yes. That is
and then Mr. Ignacio Wernicke will go second, and then we will go back to Bruno Bertini, and then followed by Joachim Beriol. That's correct? Very good. I do not know whether my co-arbitrators have any particular point to raise at this stage before we start.
Nothing at this stage for me.
Nothing from me. Thank you, Mr. President.
Perhaps I should record that because of the current COVID situation, the two teams of counsel do not avail of any junior associates today. Therefore, they will not be able to broadcast to share the screen with information. We will have to be looking at the file, and they will take account of the need for us sometimes to turn to the file from time to time. Thank you. So then, without further ado, and the time is 10 minutes past the hour, we will give the floor to Ms. Rossi.
Thank you very much, Mr. President. Members of the tribunal, opposing counsels, good morning from Uruguay. As already introduced, my name is Romina Rossi, and I will be addressing the procedural issues of this case. Members of the tribunal, claimant bases its claim on assumptions, not on facts. Respondent instead wants to discuss reality, not eventuality. Counsel for respondent will argue, firstly, that the joinder should be admitted by this tribunal, and secondly, that the hearings of these arbitral proceedings should not be conducted remotely. With the permission of this tribunal, I shall begin by addressing my first submission concerning the joinder. But before diving into it, allow me to go one step back in order to briefly explain the relevant facts of this case to this tribunal. The respondents granted 2 licenses over the same patent of a viral vector, one to the claimant and one to Ross, and each has a different scope. Although this will be further discussed on the merits, what is indeed relevant for the procedure is that now, Ross is illegitimately widening up the scope of their license up to an extent that would eventually invade claimant's license. Therefore, in order to dispel any of claimant's concerns, the joinder should be admitted by this tribunal, and this is because of 2 main reasons. Firstly, because the tribunal has the powers to do so, and secondly, because that power is justified in light of all the relevant circumstances of this case. Now, firstly, the Swiss rules that are the rules that govern these proceedings as agreed by the parties in the arbitration agreement give these powers to this tribunal concerning the joinder. Article 4.2 of the Swiss rules states that after consulting with the parties, the tribunal shall take into consideration all the relevant circumstances. This means that, firstly, the tribunal has to consult with the parties. Claimant may argue that the consent of the parties is required. However, members of the tribunal, even if it is only by 2 letters, consult is not the same as consent. In this case, the parties have consented to the Swiss rules of international arbitration that in order for the tribunal to assess the request of a joinder, only require it to consult the parties about it. Now, respondent's request to join Ross is not without merits because there is a specific rule that foresees this possibility. A specific rule that was agreed by both respondents, by the claimant, and by Ross. Subsequently, secondly, not only the tribunal
before you move to your second point, so your submission is therefore that the only thing that the tribunal needs to do in respect of a jointer is to discuss it with the parties, but then the tribunal could or should be able to make a decision in favor of the jointer, even when one party clearly disagrees, and perhaps even the person that is to be joined also disagrees with that jointer.
Allow me to clarify, Mr. President, that the tribunal should first consult with the parties and then take into account the relevant circumstances of this case in order to assess if the joinder is necessary for the case or not. But yes, indeed, it can join a person even if it does not consent, since the procedural rules give those powers to this tribunal.
And how does this sort of can be reconciled with the consensual nature of arbitration, irrespective of what the Swiss rules may say? I don't think as such that the Swiss rules are a threat to the consensual nature of arbitration or party autonomy.
Well, in this case, there is no threat to the consent of the arbitration that respondent acknowledges that is a cornerstone principle of any arbitration, because the parties have consented to the Swiss rules that the only requirement for the joinder that they set forth is a consulting. And there is an implied consent by consenting to the Swiss rules to the consent of the joinder. And not only the claimant has consented to the Swiss rules, but also Ross, because both arbitration agreements, the one between claimant and respondent number 1 and the one between respondent number 2 and Ross, are exactly the same. Now, concerning all the relevant circumstances of this case, if we go to the facts of our case, once again, those powers by the tribunal should be used, because the relevant circumstances include mainly the links between the claims, as was held by Professor Hober. Now, both claims, claimant's actual claim and Ross's potential claim, are legally linked because not only both contracts are governed by the laws of Danubia, but also, and as was raised previously, both arbitration agreements are exactly the same. Therefore, both arbitration agreements are governed by the Swiss rules. In both cases of the arbitrations, the seat is Danubia, and the tribunal is to be appointed in both cases by the institution. Therefore, members of the tribunal, this current ongoing arbitration comply with both arbitration agreements entirely. And not only this, but also these similarities were admitted by the claimant on its very own request for arbitration, which is why I would like this tribunal to join me on page 8 of the record, and please let me know when the tribunal is there.
Yep.
On page 8 of the record, we shall find the request for arbitration filed by the claimant. And on paragraph 24, the claimant stated, and I quote from the end of the second line, "We were told that this is a standard dispute resolution clause which respondent number 2 had been using," end of quote. And then on the second to last line, it is stated, and I quote, "Respondent number 2 is brought into these proceedings and bound by the arbitration clause," end of quote. Members of this tribunal, let me explain this. Respondent number 2 does not have any contractual relationship with the claimant. However, the claimant brought respondent number 2 into these proceedings and stated that it is bound by the arbitration clause. Now, claimant may argue that respondent number 2 has not objected to being in these proceedings, which is true because respondent number 2 is crucial for these proceedings. However, this was not up until the response to the request for arbitration. Therefore, in the request for arbitration, there was no consent from respondent number 2. And nevertheless, the claimant is rejecting Ross's joinder using the same arguments by which it brought respondent number 2 into these proceedings. And this is contradictory, and it is cherry picking who comes into these proceedings and who does not. Now, not only in light of all the relevant circumstances of this case, this tribunal should use those powers, but also it is convenient to do so because there is an imminent risk of contradictory awards if the joinder is not allowed. Let me explain to this tribunal a hypothetical scenario. We have this actual ongoing dispute, and then Ross initiates an arbitration against respondent number 2 concerning the scope of the license. Now, in that case, we would be having 2 parallel proceedings with 2 potentially contradictory awards because both tribunals will be ruling on the same issue, which is who has the right to develop a vaccine. And that cannot happen because there is only one option. Either claimant holds a license or Ross holds a license, but those licenses cannot overlap. Thus, even if the claimant is successful in these proceedings, if the joinder is not allowed and Ross initiates an arbitration, and if the tribunal understands in that parallel arbitration that Ross has such rights, the claimant will be unable to develop a vaccine and thus find a vaccine to this pandemic that we are all struggling to overcome. For these reasons, respondent requests this tribunal to admit the joinder of Ross so the scope of Ross's license is settled and the claimant can continue his research for a vaccine and put an end to this pandemic. Now,
before you move on, I'm a bit concerned because you seem to suggest that the scope of the arbitration is perhaps a bit broader than what the parties want it to be. Because, for example, the question of who is the license holder is not really, is not, at least to me, clearly one of the main themes of this arbitration.
Sorry, Mr. President, could you rephrase the question?
Yes, I think you seem to suggest, I understand the concept, the concern about 2 conflicting decisions coming from 2 different tribunals. But you seem to suggest that it is a part of this particular arbitration for us to decide who is the license holder in terms of developing the vaccine. And I'm not entirely sure that this is within what the reference of the case by the parties to us.
Allow me to clarify, Mr. President. The claimant initiated this arbitration because the claimant is concerned about a potential claim by Ross's IP rights, which is clarified on paragraph 26 of the request on page 8, that if the tribunal could please join me.
Yep.
It is stated, and I quote, "In the present case, the use of the Borat-CAN viral vectors may, however, be potentially restricted by an IP right of Ross Pharmaceuticals," end of quote. Therefore, in order to decide this issue and if there was a breach of the CSG, the claim of Ross is crucial.
But don't you see potentially a problem of opening up the scope of the arbitration, perhaps not infinitely, but certainly much broader than what the original reference it is? And I think as far as the tribunal is concerned, I look very much at procedure order number 1, which sets our frame of reference for this particular case. I wouldn't call it terms of reference because we don't have it.
Well, but that scope is allowed to be widened up by the Swiss rules because the joinder is a possibility that the tribunal, if the relevant circumstances of this case give rise to it, that another party joins these proceedings.
Thank you.
Now,
I have a related question. I'm sorry, Ms. Rossi. My question is related to the president, actually, and it also has to do with the requirement of jurisdiction. I want to understand what is the basis for this tribunal's jurisdiction over Ross. And in this regard, I note that you are asking us to, as part of your request for relief, to order Ross to refrain from alleging that it holds an exclusive license for research into vaccines for respiratory diseases. So what you're requesting here is basically an injunction of sorts, but doesn't this require us to interpret the Ross agreement? In order to order, for us as a tribunal, to order Ross to stop whatever it is doing, we would have to conclude that it is in breach of its own agreement. And what is this tribunal's jurisdiction to do so?
This tribunal jurisdiction is given by the procedural laws of this arbitration, namely the Swiss rules. Because when a party joins to the arbitration, if the tribunal accepts that because it has the powers to do so, then it has jurisdiction to affect that party, that joint party.
So your submission is that this tribunal's jurisdiction would arise from a procedural decision of this tribunal?
Yes.
On the basis of the law?
Yes, on the law that was agreed by Ross, claimant, and respondent number 2.
Okay, thank you.
Now moving on to my second submission, the hearings of these proceedings should not be conducted remotely. And this is because of 2 main reasons. Firstly, because it would mean a violation of the parties. And second, because even if this tribunal understands that the agreement of the parties should be set aside, it is not convenient to hold remote hearings. Now, the claimant may argue that under Article 25.4 of the Swiss rules, the tribunal has the powers to conduct remote hearings, which is true. However, that article expresses that the tribunal has to assess it by using the wording may. Respondent is not contesting the tribunal's powers to hold remote hearings, but it is stating that it should not take such approach in this case. The parties in this case have expressly chosen 2 venues for the hearings, therefore limiting and modifying the model clause of the Swiss rules, that is the basis of both arbitration agreements, and printing their intention in an express manner to conduct in-person hearings either in Danubia or in Equatorian. Therefore, the parties have not agreed to remote hearings. But even if this tribunal understands that that should be set aside, in this case, there are several technical issues that arise. And seeing that my time is about to elapse, could I ask the tribunal 40 seconds to conclude my second submission and conclude? Thank you.
The tribunal was already granting you 3 minutes if you wanted because of the question.
Thank you very much. In this case, there are several technical concerns that may arise during this arbitration. Firstly, between the countries involved, there is an important time difference of 11 hours. Therefore, if we consider that arbitrations tend to last during several months and to develop during several hours per day, the time frame in which the parties would coincide in order to conduct remote hearings is very narrow, and therefore the proceedings would extend a lot more than what was expected by the parties. Then, not only that, but also, it is known that confidentiality is one of the main reasons why people choose arbitration in front of litigation. And in this case, confidentiality is not 100% ensured in remote hearings. Confidentiality is not only important in this case because the parties have agreed to a confidentiality clause, but also because we are dealing with an issue of human health, which is the vaccine against COVID-19. And no arbitration can be conducted under the basis of an uncertainty regarding its confidentiality. Now, not only that, but also respondent may require witnesses and expert witnesses in order to prove its case. And the proper examination and production of evidence cannot be done as effectively via video conference as in an in-person hearing. And also, and last but not least, the technical equipment, it arises from the record that is better on the claimant's side. And that would mean that we have the claimant here and the respondent here. And that is not granting the parties the same level of opportunities as foreseen by Article 18 of the Danubian Arbitration Law, which is a verbatim adoption of the antitrust model law. Therefore, members of this tribunal,
as you conclude, I think I have 2 questions in relation to the virtual hearing. It seems to me that there is a sense of perhaps uncertainty about the quality of technology and also about likely sort of cybersecurity issues. I think as we now speak, there's been a good year of online hearings. And I think there's no report of any particular sort of confidentiality leaks or other breaches that have been the result of virtual hearing. So would you still maintain that the risk sort of hacking or interfering with the proceedings is so severe after we have had effectively a 12, 13 months experience of online hearings without major problems? I understand perhaps the point of,
yes,
of convenience and asymmetry of technology. That's a different question, and that's something that the tribunal will have to consider, of course.
Of course, Mr. President. Respondents still submit that because it arises from the procedural order number 2 issued by this tribunal that confidentiality is not 100% ensured in this case. However, if confidentiality was not a concern of this tribunal or of the claimant, there are a lot of factors that are relevant to take into account. And respondent submits that all these facts looked all together deserve to not conduct remote hearings. And concluding with my pleading, I respectfully request this tribunal, on behalf of my clients, the respondents, to accept the joinder of Ross and to not conduct remote hearings. Thank you very much.
If I may, just thank you very much. Just before, Mr. President, if I may, just a couple of questions on the remote hearing issue. Ms. Rossi, you raised a couple of issues, and I'm wondering whether we can't perhaps find a way through them in order to reach an agreement on this point. The first one was the extension, and I appreciate one of the challenges has been the different time zones, and I'm about to go into a final hearing where we have people in Hawaii, London, and Washington, and there is indeed some limitation on the time. But isn't the simple answer to that to find those overlapping times, even if they may be a little extreme in one or two circumstances, and have short hearing days and simply extend the length of the hearing? In that particular case, for example, we're having 4-hour hearing days, and instead of it being a 4-day hearing, it's going to be an 8-day hearing. You said that they last several months and years, but essentially that's the written procedure, which not really affected by. So I just make that as the first point, and like your reaction to that. Secondly, with regard to the confidentiality point raised by, and the inequality of technology raised by you, and then the question raised by the President, there are technologies whereby outside providers actually run the technology for the virtual hearing, and where costs of that can be shared, and where all parties receive the same equipment in order to be able to undertake the hearing. So that might be a solution in order to ensure equality in that regard. And finally, my question was in terms of efficiency and also safety. As you said, we're all struggling to overcome the pandemic. How would you address the social distancing concerns about having a live hearing and dealing with issues such as quarantining of traveling members of the arbitral tribunal? In certain countries, we would have to isolate for 14 days before we could have any contact. How you would deal with the actual physical hearing itself, because the concern is that we are under an obligation as the tribunal to determine this dispute efficiently and promptly, in order to get, one of the issues of the vaccine will be to get it out promptly. And if this dispute is being delayed because it's impossible to hold a physical hearing for reasons of constraint, that will obviously create delays and uncertainty. So there's several issues there, but I'll just list them and would be interested in your response. Thank you.
Thank you very much. The questions will be answered in the order raised. As for the first question regarding the extension of these arbitral proceedings and the time frame in which the parties could coincide, even if the parties could arrange something to coincide or to conduct the hearings in a more effective way, there is the issue of that the parties have not agreed to the remote hearings. There is the confidentiality issue that will be addressed later on. There is the proper examination and conduction of evidence in remote hearings, and there is the technical equipment issues. So even if we reach a solution concerning the time frame and the time difference, there are still a lot of reasons why it is not convenient to hold remote hearings. Now, concerning the second question of the confidentiality and outside providers and a solution that could be reached by the parties, the respondent has to consult that with the client, and if the client agrees to contract with outside providers to secure the arbitration, they will be happy to solve this, but that will be consulted with the client. And as for the third question of efficiency and safety, it does not arise from the record that there is an issue of quarantine, because precisely respondent is submitting to this tribunal to not conduct remote hearings, because out of the record, there is not a certainty that hearings cannot be conducted in person. And also there is not a certainty that they can be conducted via remote. Therefore, respondent presents to this tribunal the reasons why it should not conduct hearings via remote. Besides, the parties could agree to maintain the social distance, to go to a big room and discuss that with all the safety measures in order to safeguard the health of everyone involved in this arbitration.
Thank you very much.
Thank you. Any more questions from the tribunal before we turn to the claimant to respond?
I just have a factual question. I understand from the record, and please confirm, Ms. Rossi, if it's correct, that the tribunal, that you envisage, when exactly do you envisage that a hearing could occur, an in-person hearing could occur?
From 7 to 11 May, it arises from the procedural order number 1.
So it's, and that is confirmed that it could actually take place at that time?
No, it is not confirmed, which is why the parties are presenting the reasons to this review.
Thank you.
Okay. Thank you. So then we will turn to Ignacio Wernicke, who is going to address the procedural issues on behalf of the claimant.
Thank you, members of the tribunal. My name is Ignacio Wernicke, and I'm representing claimant, and I will address the procedural issues. Members of the tribunal, in this pandemic, just as the world needs vaccines, claimant needs an early diagnosis without any unnecessary delays. However, respondents' intentions to join a needless third person and to possibly postpone the hearings indefinitely are of no help. With this, I will mirror opposing counsel's allegations and establish that first, this tribunal should reject the joinder of Ross, and second, that the examination of witnesses and experts should be conducted remotely if an in-person hearing is not possible. To begin with the first issue, opposing counsel alleged that claimant's claim relies on assumptions and not in reality. However, opposing counsel expects from this tribunal to assume that the parties are granted an open consent to the joinder by agreeing to the Swiss rules when they in reality have not consented to the joinder. For this, as it was a concern of Mr. Mistelis, opposing counsel's interpretation of Article 4.2 may not be reconciled with the consensual nature of arbitration. And this is the case, members of the tribunal. As it was considered by Nathalie Bowser, the unconclusive wording of Article 4.2 cannot amount to an open consent of a wholly discretionary joinder as respondents request. And as it was a concern of Madame Sacco regarding the jurisdiction of this tribunal over the third party, Philip Habiger, which is the former president of the Sky Court, considers that Article 4.2 only establishes the procedural framework to join a third party, but does not create a jurisdictional basis itself of this tribunal over the third party. And indeed, as it was considered by Tobias Silverbuehler and Christoph Müller, the general consent of the parties to the Swiss rules in different arbitration agreements is insufficient to constitute consent to the joinder of a third party that is not a party of the underlying arbitration agreement that gave rise to these proceedings. And this is the case, members of the tribunal. We agree with opposing counsel that both claimant and Ross are not parties of the same arbitration agreement. And since every party involved in this case, other than respondents, are objecting to the joinder, this tribunal may not join Ross to these proceedings. Moving to the second point regarding why the circumstances of this case clearly weigh against granting the joinder. But preliminarily, as respondents are the parties requesting the joinder, they bear the burden of proof. Yet, they have not met this burden, members of the tribunal, as I will further develop in this issue. In this case, opposing counsel alleged that first, the claim between Ross Pharmaceuticals and claimant are linked, since both would be resolved under the laws of Danubia. However, members of the tribunal, this is not the case. Here, the application of Danubian contract law is contested by claimant, and this tribunal should decide if the CISG is applicable to this case, other than the contract between Ross and respondent number 2, in which the application of the CISG is not contested at all. Moving on, opposing counsel alleged, and I quote, respondent number 2 was brought to these proceedings using the same arguments that claimant uses for rejecting the joinder of Ross, end of quote. However, members of the tribunal, that is simply inaccurate, because we do not allege that respondent number 2 is not a party of the arbitration agreement under the PCLA. Indeed, we consider that respondent number 2 is bound by the arbitration agreement in the PCLA, as we stated in the notice of arbitration, since respondents are nothing but a group of companies. However, we did not allege that, since, as opposing counsel established, respondent number 2 did not contest the jurisdiction of this tribunal. Furthermore, opposing counsel alleged that there is a possibility of conflicting awards. However, as it was a concern of Mr. Mistelis, in this case, this tribunal is not expected to determine the scope of the license granted to Ross, but to determine if the goods delivered by respondent number 1 are non-conforming under the CISG. And another tribunal would have to analyze in the dispute between respondent number 2 and Ross Pharmaceuticals if there is a breach of contract of Ross under a different applicable law without analyzing any conformity of goods at all. And therefore, as it was also a concern of Mr. Mistelis, there would not be a widened scope of the arbitration agreement as respondents are requesting. Furthermore, opposing counsel omitted to mention the strong confidentiality concerns that are existent in this case. And this is because opposing counsel omitted to mention that Ross Pharmaceuticals is not any third party, but a direct competitor of claimant. And therefore, claimant should not be forced to bear the risk of going to arbitration with a party which it's not related to, it has not consented to arbitrate with, and also there is a risk of the disclosure of commercially sensitive information of claimant to a third party, which is a direct competitor, members of the tribunal.
I have a couple of questions to the point that you have made in response to Ms. Rossi's submissions. The first is, of course, you rely on substantial Swiss authority on the scope of or the legislative intent, if you wish, in inverted commas, because rules are soft law, but for 2 of the Swiss rules. But I recall, I'm old enough to recall the publication of the Swiss rules, and they were at the time celebrated as providing a new model, although based in the ancestral rules. They were providing a new model for widening the scope of arbitration by empowering tribunals to make these decisions. So you seem to say that this is a procedural opportunity, but not a jurisdictional opportunity. And I think we don't debate that as such. It's not a matter of whether the Swiss rules in this particular point expand the jurisdiction. They could, in my view, they do it in other parts, like, for example, Article 21.5. But don't you think that this invitation already exists in the rules, and this is something to be discussed sort of more fully? You make the point about the burden of proof, and that's another issue that the tribunal will have to decide. But don't you think that Article 4 already entails that invitation to consider, at least?
Just to be perfectly clear, Mr. Miselis, is it your concern if Article 4.2 is so broad that a tribunal may join a third party even if it is not a party of the arbitration agreement?
My question is whether Article 4, by the way it has been drafted, already invites the discussion, not the outcome, but the discussion, with the tribunal perhaps having the possibility to get one outcome or the other.
Yes, we are not contesting that the discussion may take place, that the tribunal, according to the wording, may consult with the parties, see their positions. However, as it was considered by, in the case, PT First Media, for a provision, in this case, Article 4.2, allow a joinder in the terms requested by respondent, that provision should have express and unambiguous language in that sense, which, according to Patocci, Article 4.2 lacks. So therefore, even though the wording, as you have noted, Mr. Mistelis, may invite the parties to discuss this topic, the tribunal should reach the decision that the unconclusive wording of Article 4.2 does not empower this tribunal to take the joinder in the terms requested by respondents. Moving to, and if the tribunal has no further questions regarding this first issue of joinder.
I see a couple of questions coming forward.
Mr. President, if I may. Yes, Mr. Wernicke, I'm having trouble understanding the reasons why your client does not wish to join Ross to the proceedings. I mean, isn't it in your client's interest for Ross to be joined? Let us assume, for the sake of argument, that we do order Ross to refrain from alleging that it has an exclusive license for research into vaccines for respiratory diseases. Doesn't this solve the dispute? You can go on making your vaccines, Ross steps aside, and everybody's happy.
To answer your concern, Madam Sacco, we reject to the joinder of Ross Pharmaceuticals because our standard of Article 4.2, as it will be further developed by Mr. Bertini, considers that the mere existence of Ross Pharmaceuticals' claim is indeed sufficient to render the goods non-conforming. And we consider that it is not necessary to have Ross itself as a party in these proceedings, nor the tribunal to determine the scope of the Ross license to resolve claimant's claim. And it is true that if Ross would stop making those allegations that it has a right over the vectors, that would give us more tranquility. However, what we are fearing, as my co-counsel will further address, is if Ross Pharmaceuticals takes the decision to take a positive action against claimant and refrains it from using the vectors for the development, and only Ross Pharmaceuticals not making those further allegations will not stop that, but also the resolution of the dispute between respondent number 2 and Ross Pharmaceuticals should not be decided at the expense of claimant's confidentiality and commercial sensitive information, and also at the expense of claimants increasing its costs and these proceedings being delayed to resolve a dispute that it isn't necessary for this claim, Madam Sacco. Moving to the, and if there are no further more further questions regarding this first issue,
you may proceed.
Just one very short follow-up question. I appreciate that there are many confidentiality concerns when dealing with delicate, intellectual property and the development of a vaccine, and one can imagine all kinds of situations where that would be concerning when dealing with. My question is don't you think that the arbitral tribunal has a discretion or the ability to address those concerns? That's to say that, where those concerns arise before delicate information is disclosed into the arbitration, that appropriate applications could be made for the protection of that information by the tribunals. In a sense, to respond to one of your concerns, how do you respond to that? The exercise by the tribunal of that power. Obviously, we're all very conscious of those concerns, and maybe a solution could be found within a single proceeding. Thank you, Mr. President.
I see that my time is about to elapse. Before answering Mr. Blackaby's question, may I have more time to answer that question and then conclude?
I think you have about three and a half minutes as well. So,
okay, thank you. Well, to answer Mr. Blackaby's concern, yes, we think that this tribunal has the power to address those concerns. However, just to be perfectly clear, It is not that, as it was Mr. Blackaby's pointed, it is not that delicate information will only appear in the evidentiary hearing, but in this case, in the file, there is confidential information such as pricing information, royalty schemes information, of whom we are not interested in having a direct competitor take knowledge of that information. And furthermore, the confidentiality measures that this tribunal may take, first, there is no guarantee that Ross Pharmaceuticals may accept those confidentiality orders, and it would object, so it may make these proceedings less efficient than they already are with a third party. And also, there is no guarantee that the counsel for Ross Pharmaceuticals will comply with those confidentiality orders. And we should not be forced to trust in counsel for Ross Pharmaceuticals, specifically if we have not consented to arbitrate with that party, and that party is a direct competitor, Mr. Blackaby.
Thank you.
Moving on to the second submission regarding remote hearings. Contrary to opposing counsel's allegations, we do not request this tribunal for an indefinite postponement of these proceedings, but rather to hold the evidentiary hearing remotely if necessary. And first, we agree with opposing counsel that this tribunal has power to order a remote hearing. And opposing counsel alleged that it would not be convenient for the tribunal to order a remote hearing. However, members of the tribunal, it is self-evident and an understatement that the circumstances in which the PCLA and the arbitration agreement cited, in which opposing counsel relied on, was concluded, are nothing but different with the ones that we are currently living. And in this pandemic, this tribunal should exercise the power it has to conduct the remote hearings, to conduct the evidentiary hearings remotely, since the circumstances call for that. And moving on to opposing counsel's concerns about technical issues. Opposing counsel alleged that the 11-hour time difference may make the evidentiary hearing troublesome for a party. However, as Mr. Blackaby pointed out, that concern may be addressed by holding shorter hearings, as the Austrian Supreme Court held in July of last year, and also as the Vienna Protocol for a remote hearing establishes. Furthermore, regarding the confidentiality concerns of opposing counsel, first, as Mr. Mistelis pointed out, there is in the record no past. There are no precedents in which there has been confidentiality breaches in a virtual hearing. But furthermore, if the parties want to prevent a cyber attack from happening, they can follow one of the many cybersecurity protocols that are currently in vogue, just as the ICCA New York Bar cybersecurity protocol, to prevent the disclosure of that information due to a cyber attack happening. And furthermore, and I'll address this last point and conclude, opposing counsel alleged that the differences between the technical equipment of the parties may entail an impairment of the equal treatment. However, members of the tribunal, opposing counsel admitted that both parties had the necessary technology to be effectively in the virtual hearing, and as Maxi Scher considered, equal treatment is complied with if both parties have the necessary technology. And therefore, since it is the case, there would be no impairment of the equal treatment. With these, members of the tribunal, I would like to conclude by requesting that first, this tribunal should reject the joinder of roles, and second, that the examination of witnesses and experts should be conducted remotely if an in-person hearing is not possible. Thank you.
I wonder whether your concept of equal treatment by having access to the hearing is perhaps a bit too low a threshold, because I mean, it's different. I mean, bandwidth is an issue. Technical capacity in particular part of the world is also an issue. Wouldn't you agree that this is genuinely a question, a technical question but we might have to defer to experts to determine whether the parties do have equal access to technology.
Yes, I agree with you, Mr. Mistelis, that there is an expert opinion if the technical equipment is sufficient. However, in the record, it shows that both parties have the necessary equipment, and it would not be reasonable to expect that both parties would have the exact same technology, the same computers, the same audio technology, since it would be expecting from the parties to not have different counsels or better lawyers than the other party. And for this, since both parties may be able to be part of the evidentiary hearing remotely and present their evidence, both parties, the equal treatment of both parties would be respected by this tribunal.
Because technically, it's not just whether the parties have the capacity. Obviously, the counsel to the parties have the technology, but whether the experts and the witnesses will also have it, which is a much bigger exercise ultimately.
I see your point, Mr. Mistelis. The record does not show if the witness or expert which will be presented, which we, by the way, we do not know which witnesses or experts will be presented, if they have the necessary technology. However, I expect from both parties to try to take all the necessary measures for those witnesses and experts to being able to present, to be effectively be part of the remote hearing.
Okay, thank you. I'm not sure whether my co-arbitrators have any questions.
No, thank you.
Then Ms. Rossi has reserved a minute for rebuttal.
Thank you, Mr. President. Members of the tribunal, when answering the question posed by Madam Arbitrator, opposing counsel stated, and I quote, "The mere existence of Ross is enough to determine the breach," end of quote. Members of the tribunal, if a mere existence of an allegation would be enough to determine a breach, no respondent would be needed in any arbitration, and a mere claim brought by a claimant would be accepted and the case would be solved. Instead, in this case, the claimant brought not only one respondent, but two. Members of the tribunal, the claimant is concerned about Ross, and when asking for solutions and when the solutions are displayed, the claimant refuses to take them. Thank you.
Thank you.
Members
Indeed, a very narrow rebuttal.
Sorry, Mr. Mistelis. Thank you. Members of the tribunal, the standards of Article 4.2 of the CISG will be developed by my co-counsel and opposing counsel on the merits. However, our submission is that if there is a legitimate expectation of the buyer that that claim may result in the use of the goods delivered being affected by a third-party right, then Article 4.2 would be triggered. And we brought to these proceedings all the necessary parties, which is respondent number 1 and respondent number 2, which indeed received the claim from Ross Pharmaceuticals, and it is the patent holder of the Gradcam vectors. Thank you.
Thank you. So if there are no further questions, then we will, which I don't think there are, we will turn to Mr. Bruno Bertini, who will continue with the merits in the case on behalf of the claimant.
Thank you, Mr. Mistelis. Members of the tribunal, claimant's business is to put vaccines on the hands of the ones who need them. And that's the reason why it contracted with respondent number 1 over the Gradcam vectors. However, respondent number 1 compromised the possibility of this vaccine seeing the light of day. This is because a third party, Ross Pharmaceuticals, is claiming exclusivity over the same Gradcam vectors, and that jeopardizes claimant's effort and research on this project. This situation amounts to a breach under the applicable law. Therefore, I will divide my pleading into 2 main submissions. First, that the applicable law to the PCLA, the contract between claimant and respondent number 1, is the CISG. And second, that respondent number 1 delivered non-conforming Gradcam vectors under its Article 42. To begin with claimant's first submission, at the heart of this dispute is the PCLA, and the parties in the PCLA agreed to be governed by Danubian law. And it's undisputed between the parties that Danubian law contains the CISG, and the CISG governs contracts with both sales and non-sales obligations under its Article 3, paragraph 2. And this provision sets forth that the CISG will not apply when the preponderant part of the seller's obligations is the provision of labor or other services. And the PCLA, as it is, falls within the scope of Article 3, Paragraph 2, as its performance has two main stages. First, a research stage, in which respondent number 1 has to deliver and license the GORACAM vectors for use in respiratory diseases, and a second stage of production, where claimant has to purchase from respondent number 1 all the necessary base materials required for the mass production of this vaccine. And in order for this tribunal to determine the preponderant part of respondent number 1's obligations, an overall assessment of the case should be made according to the CISG Advisory Council Opinion number 4. And this overall
before you go to the opinion number 4, Pilar Perales' opinion, you refer to the PCLA, and of course, if one looks at the very title of it, it is purchase, collaboration, and license. And I wonder whether that perhaps indicates that it is not mixed in the sense of having sales and services, but perhaps is sales, services, services. So I wonder whether the parties have been deliberately choosing that. I have seen, for example, in similar contexts called framework agreement or something else, but here the parties want to make a point by having two elements of the title of the agreement which are not sales.
Mr. Mistelis, our contention and our position is that the license and the collaboration part refer to the service obligations. However, the preponderant one is the purchase part in the title for these two approaches made by the CISG Advisory Council opinion. One, the economic value of the obligations, in which the purchase obligations of the PCLA surpasses the value of the services element, and also the intention of the parties. And irrespective of the approach taken by this tribunal, the result and the conclusion would be the same, that the sale of base materials is the preponderant part. With regards to the economic value, the obligation which exceeds 50% of the value of the whole contract is deemed the preponderant part. And this is the case of the sale of base materials. If the tribunal can then follow me to page 17 of the record, and if you're kind to let me know when you're there. This is the PCLA, more precisely the purchase obligations of the PCLA, which are not present in the Ross agreement. And in section 16.1, the fourth line, this tribunal can see the price to be paid by claimant for one batch of base materials, which equals 2 million euros. And these base materials are enough to produce one batch of 1 million vaccines. And when we compare these values to the license obligations for that same batch of vaccines, the price to be paid by claimant to respondent number 1 ranges from 1.5 million euros to 1 million euros, depending on the annual net sales of claimant. Therefore, this difference already shows the preponderance of the sale of base materials in this case. In addition to that, the intention of the parties also draw that conclusion. And this is not only because the parties have included a specific obligation which was not present in the template taken from the Ross agreement, but they also deviated from the practice of the industry by including this clause. And this clause is not ancillary to the performance of the contract. As it pointed out by Mr. Mistelis, it made it to the title of the contract. And there are also facts with regards to respondent number 1 that show an emphasis on this obligation. First, respondent number 1 defined itself as a contract manufacturing organization which sells and produces this base material. It also has invested considerable amounts of money to have new production lines for this production of these materials. Since it got their license from respondent number 2 to license the GORACAM viral vector, it has consistently included similar purchase obligations in all of its contracts. And most importantly, there's also an economic incentive behind respondent number 1's intentions with these base materials. And if the tribunal can follow me to page 10 of the record. And there you will see an interview made to Madam Alexandra Fleming, respondent number 1's CEO. And in the second column, second paragraph from the bottom to the top, it reads, and I quote, "The major advantage for Cambier is the recurring business of providing the required vectors and basic materials at a price which is overall around 2 to 5% higher than revenues usually generated." End of quote. This difference in the revenues generated already generates a preponderant intention on the sale of base materials, rendering the preponderant part of respondent number 1's obligations, and therefore this tribunal should conclude that the CISG applies to the PCLA in this case. And if the tribunal has no further questions on this submission,
I have one question.
Submission.
Sorry. Before you move to your second submission, you made the point about Article 16.1, which set out sort of the pricing scheme, and I wonder how would you read that part of the record with Appendix 1 to the procedure order number 2, paragraph 7. I think I just got it right. Because there you see that there is a price listed, but in addition to the price listed, there's quite a bit of discussion about research and development, which is part of the services, part of any type of contract of this type, and this is a much more significant value.
Excuse me, Mr. Mistelis, could you rephrase the question to what part you're exactly referring to, apart from the appendix?
I think I understood your argument about sort of the economic value on the basis of Article 16 of the PCLA, but I wonder whether the existence of Appendix 1, paragraph procedure order number 2, paragraph 7, which are the experts of the internal P&I of the Respivac and Cambier, modify your submission, which is entirely based on Article 16 at the moment. What does this exhibit bring to the case, or does it modify your submission at all?
Mr. Mistelis, in this case, it does not modify our submission. This appendix brings a table of forecasting of revenues and costs for both parties, in which both parties see how the contract is going to be developed, and it has a part the values of the obligations that arise from the contract and the internal costs for the production and development of this vaccine. And the research and development portion you mentioned is an internal cost from claimant, and therefore it does not enter into the analysis of the preponderance, because it's not an obligation per se in the PCLA.
Okay, thank you.
And therefore, moving to them, if there are no further questions on this topic.
Actually, Mr. President, if I may.
Yes, you may, of course.
Mr. Bertini, I see at the very beginning of clause 6.1, it says, in case of a commercialization of the product, the obligation is clearly, the purchase obligation is clearly conditional. The fact that it's conditional means that it might actually not happen, in which case the purchase element of this contract never occurs. How does this impact your argument? Do you still maintain your position that this is primarily a purchase agreement?
Excuse me, Madam Saco, you were muted in the last part.
I'm sorry. I just wanted to ask, how does this impact? What is the impact of this condition to your submission? Do you still submit that this is primarily a purchase agreement, even though the purchase element will only occur, might never occur?
Madam Saco, we stand by our submission. The fact, of course, we agree that the obligation is conditional from its plain language, but that does not change the fact that it's part of the same unified agreement made entered into by the parties. And this is a requirement under Article 3, Paragraph 2, that all of the obligations when the contract is unified had to be taken into consideration and the whole development of the PCLA is necessary to render this preponderance test as well.
Thank you.
Therefore, moving to my second submission, respondent number 1 delivered non-conforming GORACAM vectors under Article 42. And this provision sets forth that the goods are non-conforming whenever there is a right or a claim made by a third party which is based on intellectual property, where at the time of the conclusion of the contract, the seller knew or could not have been unaware of that right or claim. Therefore, I will divide my submission in 2 points. First, that there is a claim in the sense of Article 42 made by Ross Pharmaceuticals. And second, that respondent number 1 knew or could not have been unaware of this claim. With regards to the first point, I will clarify Mr. Mistelli's concern in the procedural part. The scope of this arbitration is to determine whether this claim from Ross Pharmaceuticals, as we are going to contend, falls within Article 42, irrespective of the existence or the scope of the effective right from Ross Pharmaceuticals. And this standard of claim under Article 42, as found by the Austrian Supreme Court in the CD Media case, refers to claims that can be informal and need not be legally founded. But this is not any claim that will trigger the seller's obligations under Article 42. According to Professor Stefan Kroll from the Buenos University, claims will trigger the seller's liability when there is a legitimate expectation that a future legal action will come to the buyer whenever a party asserts an intellectual property right. And this is because the aim of Article 42 is precisely to protect the buyer from litigation. And it would be unreasonable for the buyer to wait until a formal proceeding commences when there are these legitimate expectations. And members of the tribunal, before I continue, I see that my time is about to elapse, so may I have an addition of 3 minutes to continue?
Yes, you can have them because there will be a couple of questions as well in that time.
Perfect. They will be very welcome then. There are, in this case, therefore, legitimate expectations. And if the tribunal can follow me to page 35 of the record, this is an email, which is the core of our claim, sent by Ross Pharmaceuticals, more specifically, Madame Julia Bordet, who is head of IP at Ross Pharmaceuticals. And this was sent to Mr. Peter Doherty, who was at that time Director Legal at Respondent number 2 and the main negotiator at Respondent number 1 of the PCLA. And the second paragraph, Ross Pharmaceuticals asserts that it has paid a considerable amount of money to extend its license from malaria to malaria and related infectious diseases. And in the 5th line of the paragraph, it reads, and I quote, "In our view, those would also cover infectious respiratory diseases," end of quote. Here, Ross Pharmaceuticals is asserting that it has an exclusive right over infectious respiratory diseases, the same scope that claimant has in its license. But this is not the only concern claimant has. Ross Pharmaceuticals, as stated also by my co-counsel, is just not any third party. It's an exclusive licensee of the GORACAM vectors, therefore it can exclude others from the use. It firmly believes that it has an exclusive right over the GORACAM vectors. It has a tradition of vigorously enforcing its IP rights, and it has, in fact, a whole department dedicated only to IP litigation. And it is not only asserting that it has this right, it has been exercising it since 2018, and is now trying to achieve a COVID-19 vaccine, just like as claimant is trying to do so.
May I interrupt you? Oh, sorry.
Yes. No, go ahead.
Mr. President. No, I just wanted to make the point that despite everything you have said, I believe it is undisputed, Mr. Bertini, that you have not, that Ross has not initiated an IP claim against claimant. Is that correct?
Madam Sacco, that is correct. There is no formal IP litigation raised against claimant, But the fact that there are these legitimate expectations because of these facts I have enumerated, it makes unreasonable for claimant to wait until this proceeding begins, because claimant is put between a rock and a hard place. It does not know whether to continue with its research or not, because this will lead to losses in any way. It can stop now and lose everything on its research and investments, or it can continue. It might develop a vaccine, but maybe in the future, Ross Pharmaceuticals will obtain an injunction against claimant, and therefore claimant will not be able to commercialize this vaccine. It will not be able to make profit out of it, and it will lose all of its investments, research, and efforts on this project.
But isn't the whole discussion a bit premature? Because I mean, my main concern is the question about related diseases, and I fail to see how that COVID and respiratory diseases is related to the license that is already in place. One could easily make the case that these respiratory diseases and COVID are very different to what the license is granted for.
Mr. Vitelis, one could make the argument that respiratory diseases are not related to malaria, but as the scope is broad enough to leave the door open to discussion, and the fact that a tribunal or a court might have to decide on that scope is sufficient for claimant being possibly facing a claim in the future, and therefore prematurely also, Ross Pharmaceuticals may ask for an injunction, for example, or a cease and desist order against claimant, and that already jeopardizes claimant's efforts in this case. And to quickly continue with my
sorry, can I just make a follow-up question if there's no other questions on that? I mean, this reminds me a little bit of the situation we had in between the EU and the UK with regard to the AstraZeneca vaccine, where essentially you had, I'm just not thinking if it's a good analogy or not, but you had a production facility in the UK for AstraZeneca vaccines, and the understanding was there was a contract to supply the UK with those vaccines. And the European Union effectively said that no, its contract, or it required that those vaccines be distributed or sent to the European Union. And in those circumstances, on the same analysis you're undertaking, the UK would have an action against AstraZeneca before any interpretation of that contract had taken place. Is that a fair analogy, or am I missing something?
Mr. Blackaby, unfortunately, I'm not into the specifics of that exact case, but if that case had such big legitimate expectations, and in this case have that AstraZeneca will have a lawsuit that will prevent the commercialization of that vaccine, in this case, it will be in sort of way analogous to this case, but it will not be able to make a profit of the same business that actually AstraZeneca and my client have at this point.
But doesn't that require, as the president indicated, a prior determination of the contractual rights that could potentially affect your rights, and that prior to that determination, the claim is not mature, is not right?
In this case, Mr. Blackaby, no, because Ross Pharmaceuticals may prematurely have some orders, like preliminary injunctions on cease and desist orders, to cover these rights, and a court or a tribunal may grant those orders, and that will be an affectation of claimant's rights without even for the tribunal to resolve on the precise scope of the Ross license.
But that's precisely the point. Now that those injunctions don't yet exist.
And may I add an element to the mix, which is that the respondent is actually offering to bring Ross into the arbitration so that this tribunal can order it to stop, and you don't want them to join. Wouldn't that deal with how legitimate is your expectation, knowing that there is a possibility that Ross might be ordered to stop and you are not allowing it?
In this case, as we stand by our submission, Madam Sacco, that it is not necessary for Ross to join to these proceedings because it will still have the possibility to prevent claimant's suit, irrespective of what this tribunal may order if joined, apart from the fact that Ross Pharmaceuticals is not accepting a jurisdiction of this tribunal. And with regards to Mr. Blackaby's question, I couldn't hear the last part. If you can rephrase.
No, it was simply that it seems on the face of it, and I'm not making any decision here, but just to play the sort of the devil's advocate, it seems that that the concern which you're raising is not yet ripe, because there is no proceeding, as I understand it, and there is no pending issue. So if your position were right, would it not mean that any third party challenging rights that could affect any goods that were delivered under a separate contract, however weak or strong that claim might be, would effectively imply the liability of the seller in those circumstances? And isn't that a very high responsibility for the seller, because it would depend upon the actions of third parties that may or may not be well-founded? And if they're not well-founded, that would seem to place the seller in a very difficult position. And here we don't know whether these claims are well-founded or not, because they've not been adjudicated.
Mr. Blackaby, to respond to your question, it's our position that this claim does not need to be well-founded to trigger the seller's liability, in conjunction with all the surrounding aspects of this case and facts that draw to this conclusion that Ross Pharmaceuticals will at some point make a lawsuit against claimant. And this was found by the Austrian Supreme Court in the City Media case as well, because it's within the seller's sphere of risk to deal with these claims, as Article 42 also limits very heavily the responsibility on the seller with all the other requirements under its warrant. Therefore, given the time constraints of this proceeding, I would like to conclude by requesting this tribunal to find, first, that the CISG applies to the PCLA, and second, that respondent number 1 delivered non-conforming GORAC and vectors. Thank you.
Thank you. Then we can turn to Mr. Meriolo, who is going to present the arguments of the merits on behalf of the respondent.
Indeed. Thank you very much. Well, good morning, members of the tribunal, opposing counsel. As already introduced by my co-counsel, my name is Joaquin Meriolo, and I will be addressing the merits of the present arbitration on behalf of respondent. Members of the panel, claimant does not have a crystal ball to see the future. It is certain that its rights will be violated, yet not only has Ross Pharmaceuticals not initiated any claims whatsoever, but also the rights licensed to each party do not collide in any way. Respondent will address its submissions in the same order as chosen by claimant and thus argue, first, that the PCLA does not fall within the scope of the CISG, and second, even if the CISG were applicable, respondent still delivered perfectly conforming goods pursuant to Article 42. So with the permission of this tribunal, I shall begin with my first submission. Thank you. Now, we agree with the opposing counsel's statement that we are dealing with a mixed contract. However, we do not agree with their interpretation that the preponderant part of the agreement is the purchase element. We submit that the preponderant part of the PCLA is the license. Now, the reasons for the previous statements are the following. First of all, the economic value criterion is not fit to define the nature of this complex agreement. Secondly, the negotiations between the parties and subsequent wording of the PCLA show the real intention to celebrate a license agreement with subsidiary and conditional purchase obligations. And thirdly, Clause 16 is not only conditional, but merely an initial framework for the parties to celebrate a future agreement. Now, with regards to the first point, according to the CISG Advisory Council's opinion number 4, which the opposing counsel cherry-picked items from, the economic value criterion does not apply when the value is impossible or inconvenient to determine. And in this sense, if I may direct this tribunal to page 13 of the record, at the very end of the page, we can see clause 9.2, which includes the payment terms of the agreements. In this particular clause, we can read, and I quote, upfront payment in consideration of the delivery of the first batch of GORACAM viral vectors and the non-exclusive access to licensed source licensed technology Licensee shall pay to licensor a one-time upfront payment of 2.5 million euros. End of quote. Now, this clause, members of the panel, does not clarify which part of those 2.5 million euros corresponds to the license and which part to the vectors. Therefore, given that it is impossible to determine the actual value of the license and of the vectors, and since the parties did not foresee any criteria to define this issue, then it is impossible to define a value, making the economic value criterion inapplicable. Now, concerning the essential value criterion, which is the standard to be applied when the economic one fails, the Advisory Council has also understood that in order to determine what is the substantial part of the agreement, one must perform an overall assessment of the contract. Now, this overall assessment must be done through the interpretation of the parties' intentions, which can be deciphered from their conducts and their statements. And this will also explain the second point about the negotiations between the parties. Now, the opposing counsel stated, and I quote, "We must analyze the obligations of the contract unified." However, he only centered on clause 16 of the contract. And in fact, when the opposing counsel was asked about the appendix, he stated, and I quote once again, "This element does not enter as an obligation of the contract." We absolutely agree with this submission by the opposing counsel, since clause 16 and the corresponding data included in the appendix is not effective as of this moment, since the clause is conditional. Now, regarding the assessment of the actual intentions of the parties, please join me in page 30 of the record, where we can see a statement by Mr. Doherty, who, as mentioned by the opposing counsel, drafted this agreement. He is the head of contract at respondent number 1. And in the 7th paragraph, it reads, and I quote, "The draft prepared by me also formed the basis for our agreement with Respivac. Originally, my predecessor fell sick during the negotiations and had submitted the standard model contract which respondent 1 used for its customers for contract manufacturing." And the following is the most important part from this quote. "Respivac had, however, serious objections against some of the provisions and was in particular of the view that the model would not sufficiently take into account the IP element involved." End of quote. This statement, members of the panel, shows how it was not only respondent who wished to grant the license for the use of the vectors, but rather it was actually claimant who was adamant on ensuring a well-protected license. That is the same claimant which is now alleging that it was always desiring to celebrate a contract of sale, who at the time of the negotiations had big concerns on making the license clear, that it actually decided to refuse an initial template and request a new one be drafted. Now, as raised by Mr. President, the title of the agreement foresees 3 terms, of which only one talks about the term purchase, while the remaining 2 speak about services obligations, to which the CASG will not apply in this case. Furthermore, and with regards to the third and last point mentioned, if I may direct the tribune to page 17 of the record, there we shall see the clause 16 of the contract, which the opposing counsel called, and I quote, "the obligation of claimants to purchase the vaccines," end of quote. This clause, as we can see, contains 3 sub-clauses. And if we can read from the first one, that is the one titled purchase obligation, and I quote, "In case of a commercialization of the product, licensee will acquire its need of HEK 294 cells and cell culture medium," end of quote. The second sub-clause states, and I quote once again, "Production option. The licensee has the option to request licensor to produce the vaccines under GMP conditions," end of quote. And sub-clause 3 contains a scheme of royalties. Now, first of all, we must take into account that clause 16 is only an initial framework for the parties to further negotiate if a vaccine was found to be successful. Now, if the parties were to reach a future agreement, that is, if the research was successful indeed, if a vaccine was created, if it was approved by authorities, and if it was commercialized. Now, the second element we can see with clarity is that this clause, as raised by Madam Arbitrator, is conditional. And a contract's nature, such a complex contract's nature, should not be dependent on an uncertainty, that is a presently unfulfilled condition. However, that is precisely what claimant intends to do. As we previously read, the terms used are, and I quote, in case of and has the option to, end of quote. And these are terms that describe possibility or eventuality, not certainty. As mentioned by Madam Arbitrator, and I quote, the purchase element may never occur, end of quote. Now, also, the opposing counsel quoted page 10 of the record to allege that it was only respondent who wanted for clause 16 to be included in order to make use of its production facilities. However, if I may direct the tribunal to page 10, on the 5th paragraph, which begins by one of the major differences, it reads, and I quote, one of the major differences of the Gurkhan vector to other viral vectors are the difficulties in its creation and associated high production costs. These two features, however, make the Gurkhan vector so interesting for companies such as Cambria. Many companies involved in the production of vaccines lack the necessary know-how and technical equipment to breed the Gurkhan vector themselves from an original batch delivered. End of quote. Now, this, members of the panel, shows that it was actually claimant who required for this conditional purchase obligation to be included, since claimant at the time of the signing did not have the means to successfully produce a vaccine. However, and to further reflect on the fact that this clause is merely conditional, the reason for the inclusion of this clause is, unlike what the opposing counsel stated, not just the benefit of respondent, who would still have benefited from gaining royalties for the use of the license, which is of course the main element of this agreement, but it was in fact to protect claimants. Clause 16 is conditional because if the research were to be unsuccessful and not provide a useful drug against COVID, then claimant would not be forced to purchase vaccines which it would have no use for, since no successful drug could have been found. Now,
if I may intercept here, I think your arguments about the option to purchase is quite compelling, and of course, in any contract which entails an element of research and development, and we've seen that very widely in the context of the COVID vaccination programs by many sort of commercial providers and others, that things might work or might not work. This, however, does not really address the question as to whether the CISG as an international treaty, which has now more than 40 years of practice, could provide a neutral and well sort of developed system to allocate risks between rights and obligations of the parties, whether that is through Article 42 or whether through Article 4. And I think in relation to Article 4, you do provide very strong arguments why the economic argument might not work, but of course the surrounding circumstances and putting everything into perspective might put a bit of a gloss to that sort of strong submission you had on the economic element of the balance.
Well, Mr. President, of course, we absolutely agree that the CSG is indeed a neutral and well-developed system for most contracts. However, in the present scenario, the preponderant obligations of the PCLA are not of sale, they are rather of services, as the license is the main purpose of the agreement. Without the license, the Gurkhan vectors, which the opposing counsel mentioned were sold and constitute the preponderant part of the agreement, without the license, those vectors are completely useless to any party. This is why the license is so important and the patent for the know-how is so valuable. Now,
so why this was not called a license cooperation and purchase agreement, and it was called a purchase cooperation and license agreement?
Well, Mr. President, because of course claimant thought it was not sufficient to understand its final intention were a successful vaccine to be found. However, of course, we agree that titles are usually indicative of the content of an agreement. Regardless of this, there are other elements of this agreement that are very important, as the collaboration and research part is of vital importance, since without research, no successful vaccine can be found. And on that matter, without a license for the use of the intellectual property, no research could actually take place. Now, regarding my second submission, not only did the parties derogate from Article 42 of the Convention, but even if the CASG were applicable, respondent would still have delivered perfectly conforming goods under this article. Firstly, and before diving into my second submission, if I may request for an extra 3 minutes to address the second point and conclude.
Yes, you might have them.
Thank you very much. Well, first of all, members of the panel, if you could join me in page 16 of the record, at the very top, we can see clause 11.14, which is about representations that were made from licensor, respondent to licensee, claimant. And this clause states, and I quote, "There are to licensor's knowledge no claims, judgments, or settlements pending with respect to the licensed technology." End of quote. This, members of the tribunal, compared to the wording of Article 42, constitutes a implied derogation from Article 42 of the CASG, of course, making use of the right granted by Article 6 of the Convention to derogate, since the term used in the agreement is claims, judgments, or settlements pending. Now, even if this tribunal were to consider that Article 42 is to apply, then we must make one fact absolutely clear. As of this present moment, Ross Pharmaceuticals has not initiated any claims whatsoever regarding the IP rights in question in the present proceedings. In fact, the opposing counsel quoted Professor Kroll, who stated, and I quote, "Claims will be those which will cause a legitimate expectation of future appearance," end of quote. Members of the panel, we absolutely agree with this statement by Professor Kroll. However, there is no legitimate expectation of a claim appearing in the present situation, since, as correctly explained by my co-counsel, the only reason we have reached this dispute is claimant's allegation that the mere risk of a potential IP rights claim is enough to cause respondent to be non-compliant. Now,
I just make an excuse me, with the permission of Mr. President, just to test that proposition. I mean, the essence of IP rights, I mean, that is something fundamental to ensure that there is no competition, that there is an exclusivity, that, I mean, that's the essential value of everything that Ross thinks it has. So, I mean, what's your position that even if there has not been a formal claim notified, that in reality, given the conflicting rights and the assertions that have been made by Ross, isn't it almost inevitable that should this proceed, there will be a claim by Ross? I mean, this is a formal requirement? There needs to be a letter where Ross is formally starting a claim in order for this to cut in, or would it be to a more sort of commercial approach whereby you say, look, looking at all of the facts, it's highly likely that there will be a claim and that therefore you've not sold me what you said you were going to sell me?
Well, Mr. Arbitrator, in fact, it is our submission that the lack of any formal, that is arbitral or judicial litigation being in place at the present time constitutes no liability for respondents. In fact, as the opposing counsel himself stated, there is no formal IP litigation presented against claimant. Now, regarding the likelihood of a claim being presented in the future, the facts of the case do not show that that is actually a possibility. Now, claimant indeed argues that not only the license held by Ross directly collides with the one. Yes, do you have a question, Mr. Arbitrator?
No. I was reading on the screen the Article 42 carefully again.
Yes. Well, Mr. Arbitration, first of all, on the substantial element of Ross's license, the opposing counsel himself stated, and I quote, "One could indeed argue that malaria and COVID are not related infectious diseases," end of quote. Now, the opposing counsel himself mentioned the email sent by Ms. Bourdet from Ross as the heart of the claim of claimant. Now, in that email, what the opposing counsel conveniently failed to mention is that Ms. Bourdet offers to respondent a new agreement to be celebrated. That is, Ms. Bourdet stated that if respondent's interpretation of the agreement were to prevail, then Ross would be acceptant of a new license, but this license would have to be non-royalty bearing. This clearly shows that Ross Pharmaceuticals' intention is not actually to make use of its actual rights that were granted in the Ross agreement, but to illegitimately extend the scope of its license. In fact, as the opposing counsel insisted, and I quote, Ross has a tradition of enforcing its IP rights, end of quote, and if the Ross agreement indeed collided with the PCLA, then Ross would have already initiated formal litigation. However, this is not the case. The opposing counsel only relied its submissions on the allegation that Ross may possibly initiate a claim or injunction. In fact, however, as Mr. Arbiter himself raised, and the opposing counsel had to acknowledge, said claim, and I quote, has not been put forward at all, end of quote. So no pending issues are in place. Also, as Mr. Arbiter also raised to the opposing counsel, if any claim, whether or not well-founded, would cause the seller to be liable, then that would be a very high degree of responsibility. And this, members of the tribunal, this type of responsibility is not foreseen neither by the CISG nor by the PCLA. So to briefly conclude, we respectfully request the tribunal to reject claimant's claim that respondent has breached its obligations. Thank you.
Thank you. I mean, both parties have reserved a minute for rebuttal. I'm not sure whether they want to exercise it. Mr. Bettini?
Yes. Thank you, Mr. Misteris. Opposing counsel stated that the importance of the license was given in the fact that claimant could not produce the Goracam viral vectors themselves. But this allegation seems contradictory with the same base materials in the contract, because claimant can also not produce the base materials for mass production, and the hex cells are necessary to amplify the Goracam vector in a better and more economic possible way rather than other base materials. And if the license was important because of that, they would have put it a bigger price than the price put to the same base materials in the contract as forecasted by both of the parties in the agreement. Thank you.
Thank you. And Mr. Veriolo?
Members of the panel, the reality is that without the license, no vectors, no research, no cells, and no vaccine could exist. Therefore, the license is the most essential part of the PCLA. Thank you.
Thank you very much. I think you both have delivered very forceful submissions. We are grateful not to have to deliver judgment and award. So you never know what we think on the topic. So all questions have been made for the sake of being made and to further the arguments. But we will have to deliberate in the next few minutes and decide which of the two teams have prevailed. And then you would allow us to have the time to do our deliberation. But before we break out, I suppose I have to congratulate all of you also on behalf of my co-arbitrators for truly excellent performances.
Thank you very much. It was a pleasure for us.
Thank you very much for us as well.